Hi everyone, it's John Mitchell. In today's video, we're going to look at dispute resolution. So in previous videos on workplace relations, we've stated that things don't always go to plan within a business and that disputes can sometimes arise, whether that be between two employees or an employee and a specific manager or an employee and the business in general. So there's lots of different reasons why a dispute can occur, but I've got a list of common reasons just here on the screen, including that it could be during the negotiation of a new wage agreement. Sometimes negotiations can break down as employees fight for, higher wages or improved conditions, and that can cause conflict as the negotiations actually break down. Now, some employees may cause a dispute over job security. There may be managerial policies that the business is actually trying to implement, which can cause dispute with the employees. A really common reason for disputes is over occupational health and safety. So if there's any safety concerns that the employees have, that can cause disputes, or disputes can arise over bullying or harassment, or as I said earlier, that it can be a whole range of reasons why disputes can occur, but they're just some of the common ones. So when a dispute does arise, the aim of the manager is to resolve it so that positive relationships can be maintained and that the employees can actually get back to work being productive and are also motivated in their work. Now, for that to happen, it's important that all disputes are taken seriously. No matter how trivial a manager feels that the dispute is, businesses should have processes in place so that disputes can be dealt with in a really consistent manner, which enables them to be dealt with fairly. Now, before we move on to dispute resolution methods that are in our study design, I want to firstly speak about industrial action. Now, this may be stepping outside the study design slightly. However, I think it's important for you to understand because it can be a large part of dispute resolution in many businesses. Now, industrial action is a really common form of dispute that can arise if the negotiations of a new wage agreement have broken down. Now, if you think back to an earlier video, we spoke about enterprise bargaining being the negotiation of a new wage agreement at workplace level or between the business and their employees or their respective representatives. Well, disputes can often occur if these negotiations break down, which results in one or more parties taking what is known as industrial action. So some common forms of industrial action are strikes, which is where employees actually withdraw themselves from work for a specified period of time. That's one of the most common forms of industrial action. Other forms are work to rule, which is where workers only perform the bare minimum required rather than working hard to go above and beyond for their business. They simply perform the minimum duties that are expected of them. Also, stop work meetings is another form of industrial action. This is where employees actually stop work to hold a meeting during work hours, which obviously negatively impacts productivity. And now, the first three of those that we just went through are actions that employees can take, but a lockout is the most common form of action that an employer will take. So a lockout is where the employer won't let the employees into the workplace and therefore prevents them from earning money during that time. Now, in terms of industrial action, there are two main types. There's protected industrial action and unprotected industrial action. Protected action is the action taken that is actually approved by the Fair Work Commission and is therefore deemed lawful. Unprotected action is unlawful because the Fair Work Commission has not approved it or has disapproved of it, of that particular action, and therefore damages can be sought for loss of income because it would be deemed unlawful. Now, for the industrial action to be approved as protected, the Fair Work Commission will ensure that a number of requirements have been met. So here's just a few examples of that. So industrial action can only occur when the existing agreement has actually passed its expiry date and therefore the employees and the business are in a negotiation period for their new agreement. Both parties have to have genuinely tried to reach an agreement. Employees can't simply go on a strike or any other form of action for that matter without trying to reach an agreement first. They can only take it when negotiations have actually broken down and they have genuinely tried to reach an agreement. Now, the action must then be authorised by a secret ballot, which simply means an anonymous vote needs to be taken. So if the employees in a particular business want to take action, more than 50% need to have voted yes in order for that action to be taken. And also another requirement is that the employer needs to be given the required notice so that they can make preparations around that particular action. So now that we know about disputes and the type of industrial action, we can move on to looking at how a business can actually resolve a dispute. So this isn't resolving disputes that only involve industrial action. This is resolving any disputes within a workplace. And so there's three separate methods that are listed in our study design. And the first one is a grievance procedure, which is a formal process where an employee can resolve matters relating to complaints within the workplace. So let's say two employees have a dispute and they're not happy about each other, so they're putting forward a complaint. Well, maybe the first step in a grievance procedure might be for them to try and work it out themselves. However, if it's not resolved, it might be that they need to include their supervisor, and the supervisor gets involved to try and help resolve the dispute. If that doesn't work, maybe then it's escalated to the human resource manager, and the human resource manager gets involved to help resolve the dispute and put forward ideas or actually make a decision on what the resolution is going to be. So as a grievance procedure is simply a set of steps on how an employee or how a particular individual within the business is actually going to resolve the dispute. So therefore it's done fairly and consistently because there is a clear set of steps there on how to resolve each workplace dispute within the business. The next method is mediation. So this is a method whereby a third party facilitates the conversation between the two disputing parties. So it's important to note that the parties come to their own agreement. The third party is independent and is often agreed upon by both parties in the dispute, but it's important to note that they simply facilitate the conversation. They are not making suggestions. They are not involved in the resolution of a dispute. The two disputing parties come to their own agreement. All that the mediator does is help facilitate the conversation. So if negotiations have broken down and they continue to argue, well, what can happen is the mediator simply helps facilitate the conversation so that both disputing parties can be heard and they're listening to each other. The final dispute resolution method in our study design is arbitration. So this is where both parties put their case forward to an independent third party known as the arbitrator, who then makes the final decision. So we looked at mediation before, where the two disputing parties come to their final decision on how to resolve the dispute. In arbitration, that is handed over to the independent third party. So the Fair Work Commission can act as an independent tribunal to carry out the arbitration process. So this is where both parties, they've got a dispute, they put their cases forward. The independent third party listens to those cases and makes a final decision on the resolution of a dispute. Now, just to recap, so we went through disputes and some of the reasons why disputes can arise. We also looked at different types of industrial action and looked at protected and unprotected industrial action. Remember, protected is where the Fair Work Commission has approved of that action and therefore it is lawful. Unprotected, obviously, is where it hasn't been approved by the Fair Work Commission. And then we looked at the different processes of resolving conflict or resolving disputes that are in our study design. So we looked at the grievance procedure, mediation, and arbitration. Before we finish, just wanted to make a note about conciliation, because I know lots of you will learn about conciliation. It is not in our study design, and that's the reason why it's not in this particular video. But if you have learned it in class, there's no reason why you can't use that in your answers where it's appropriate. For questions, activities, and to find out more about our Unit 4 and exam preparation lectures, then come on over to teachingbubble.com.